Hello, all of you. I'm here to discuss the prelims questions of polity and constitution. And probably I have the question that is set B with me. Uh, all the questions are same in all the sets, just that their order varies. So irrespective of which set you got, the questions would remain same. So I'll start from the first question given in the set that I have. Parliamentary system of government is one in which all political parties in the parliament are represented in the government is the option A. Option B, the government is responsible to the parliament and can be removed by it. This is the correct answer. B is the correct answer because yes, government is responsible to the parliament. In fact, parliamentary form of government is also called responsible government. The presidential form is called the non-responsible government because the lawmakers are not responsible or not accountable to the legislature in a presidential form, contrary to the parliament form. We all know, if you have studied Indian Constitution, you will know that parliament makes the government more accountable. There are several methods of doing so. So B is the correct answer. Next question, which part of the Constitution of India declares the ideal of welfare state? The correct answer is option A, Directive Principles of State Policy. It is the DPSP and not Fundamental Rights Preamble or 7th Schedule as given in other options. The entire aim of DPSP is to promote the idea of welfare state. There are three classifications of DPSP, the Gandhian, the liberal intellectual, and the socialist one. And all of them focus on making India a welfare state. So it would be DPSP. Very straightforward question this is. Next question, consider the following statements. Number one, Constitution of India defines its basic structure in terms of, now here the statement becomes wrong. It's not the Constitution of India, but the Supreme Court that gave basic structure. There is nothing like basic structure in Indian Constitution. So first statement is wrong. Second, Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the idea on which the Constitution is based. Yes, Article 13 of the Indian Constitution has implicit provisions of judicial review. The idea is to protect the citizen liberty and to preserve the ideals. Like, what if the legislature passes a law or executive makes a policy that contravenes, that is against citizens' liberty? So Supreme Court can always take a review of it. So it's a judiciary that could go for judicial review. It is given in Article 13. So the correct answer here would be B, 2 only. First statement is wrong here. Next question, which a lot of students have asked from me, they have sent me messages, they have pinged me on this WhatsApp and Telegram. One common agreement between Gandhism and Marxism. See, forget all other statements. Just remember that Gandhi is called Marx without guns, and Marx is called Gandhi with guns. They aim for the same thing, that is a stateless society. Gandhi is called Gandhi is also an anarchist. Marx, of course, is an anarchist. Gandhi is called a moral anarchist because he does not endorse violence. Marx does. So the final stage of communism is the ideal communist state, which shall have no state, which shall have no class. Something similar Gandhi also talked about. His Gram Swaraj, if realized in full, would lead to a stateless society. He was not in favor of a strong central government. He wanted autonomous village units and subsequently no authority because he's an anarchist. Of course, a moral one. So A is the correct answer. Next question, in the context of India, which one of the following is the characteristic appropriate for bureaucracy? Last option D, an agency for the implementation of public policy. Option C, agency for facilitating political stability and economic growth is wrong. The first two options are wrong. The last one is correct because bureaucracy is the forefront in implementing the public policy. It is the bureaucracy that implements the policy, the permanent executive, the civil servants, the political executives, that is MPs and MLAs, make law in the parliament and or in the state assembly if it is if they are MLAs. So it is up to the bureaucrats to implement the public policy always. Preamble to the Constitution of India is, next question, the preamble to the Constitution of India is a part of the Constitution but has no legal effect. No, it has legal effect. So this is wrong. Second, not a part of Constitution and has no legal effect. Of course, it's a part of Constitution. C, a part of the Constitution and has the same legal effect as any other part, and D, a part of the constitution but has no legal effect independently of other parts. To my understanding, D is the correct option, because read it again, a part of the constitution but has no legal effect independently of the other parts. This, you need to remember that preamble is post Beriberi Union case. Supreme Court has said that preamble is a part of the constitution. It has maintained this fact, and preamble is non-justiciable. Its provisions are not enforceable in courts, but preamble can be very useful when any act or any article is having an ambiguous meaning, which is capable of more than one meaning. The courts can always refer to the preamble to derive at the correct meaning of a particular act. So that makes option D the most feasible option of all. A part of the constitution but has no legal effect independently of the other parts. Of course, it is to be seen in the context of the entire constitution. So D would be the correct answer here. Now the next polity question, with reference to the provisions contained in part 4 of the Constitution of India, which of the following statement is or are correct? 1, they shall be enforceable by court. Part 4 means DPSP. So DPSPs are not enforceable by courts. First statement is wrong. Second, they shall not be enforced by any court. This is correct. Third, the principle laid down in this part are to influence the making of laws by the state. Yes, the function of DPSP, in fact, someone famously said in the Constituent Assembly itself that DPSPs can be the best election manifesto for any party, which means they were saying that if any party tries to, election manifesto is the promises that parties make before elections, that if we win the election, we will implement this. So they were of the opinion, if you include DPSP, public will be very happy and they will vote you. So of course, they give directions that subsequent laws should be passed, subsequent policy should be made as per the DPSP. So third option is correct. That makes option D, that is 2 and 3, as the correct option here. Now, next question, consider the following statements. 1, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if she is not a member of the legislature of that state. Try to analyze this statement. According to the Constitution, which means it is asking a constitutional provision. A person who is eligible to vote. Now, who is eligible to vote in India? Anyone 18 and above years. Anyone who is of the age of 18 and above is eligible to vote. So who is eligible to vote would be 18, can be made a minister in a state for 6 months. Who can become a minister in a state? An MLA or an MLC if it's a bicameral legislature. Few states, 6 states have bicameral assembly now. So for an MLA, the eligibility is 25 years, and for an MLC, it is 30 years. So this makes this statement wrong. Why? A person who is eligible to vote can be made a minister in a state for 6 months. No. 18 years is eligible to vote, but in order to become an MLA, you have to be 25. In order to be an MLC, you have to be 30. So this statement becomes wrong. Second statement, according to the Representation of People Act 1951, a person convicted of a criminal offense and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. Now, let us try to understand and analyze this statement also. It quotes RPA 1951 as is given here. Section 8 clause 3 of the RPA 1951 says that if an MP or an MLA, it can be MP in the parliament and MLA in the assembly, is convicted for any crime and is sent to jail for 2 years or more. So this 5-year condition would be fulfilled, which is given in the question, because it says imprisonment for 5 years in the second statement. So is sent to jail for 2 years or more, she will be disqualified for 6 years from the time of its release. This is section 8 clause 3 of the RPA Act 1951. It nowhere says that he will be disqualified from contesting an election even after his release. No, he will be disqualified for 6 years from the time of his release, which means if a convict is released today, he completes his term, he is released today, then today plus 6 years, he is eligible to contest an election. It's not what is given in the question, disqualified from even after his release from prison. The time is not mentioned here. It is 6 years. So this makes the second statement also wrong. So here D would be the correct answer. Neither 1 nor 2. because it simply does not mention the he's not permanently disqualified as given in the question 6 years after he's released. Next question. Consider the following statement. First, the President of India can summon a session of the Parliament at such place as he or she thinks fit. Yes, Article 85, Clause 1 of the Indian Constitution enables the President. The first statement of this question, which is written, it is directly quoted from Article 85, Clause 1 of the Indian Constitution. Second, Constitution of India provides for 3 sessions of the no. It is not the Constitution that provides. There are 3 sessions: budget, monsoon, and winter, but they come from the conventions. It is nowhere mentioned in the Constitution. There is no article that discusses it. Next, there is no minimum number of days that the Parliament is required to meet in a year. Yes, there is no minimum number of days that the you see just now due to COVID, the ongoing session was completed, and it was completed in very less time. So there is no minimum number of days that is qualified, that is mentioned, that Parliament must meet for these many number of days. There has to be not more than 6 months gap between 2 subsequent sessions of Parliament. That is also mentioned in the Constitution. But the number of days, minimum number of days or maximum days, these are not specially mentioned in the Constitution. So third is correct. So that makes C the correct option. A, 1 and 3. 2 is wrong because sessions are not mentioned in Constitution. It depends on the conventions, the parliamentary conventions. Now 31st question, Aadhaar. Aadhaar metadata cannot be stored for more than 3 months. So if you read the Aadhaar verdict, Kutuswamy judgment, it is not 3 months, it is 6 months. So given it, 31 first statement would be wrong. More than 3 months, the correct option is more than 6 months. The first statement is wrong. Second, state cannot enter into any contract with private corporations for sharing of Aadhaar data. This is correct. This is from the Act itself. Aadhaar is mandatory for obtaining insurance products. Nothing like that. No, that's not the case. But fourth statement is again correct. Aadhaar is mandatory for getting benefits funded out of the CFI. Yes, government said this, Supreme Court accepted it. So B, that is 2 and 4 would be the correct option. B would be the correct option in this question. 2 and 4 are the 2 correct options. Now next you see, Rajya Sabha has equal power with Lok Sabha in option A. The matter of creating All India services, no. The resolution can only come in Rajya Sabha. Lok Sabha cannot do. There are 3 All India services: Indian Administrative Service, Indian Police Service, Indian Forest Service. If there has to be a 4th All India service, it has to be the motion has to come in Rajya Sabha. Lok Sabha cannot do anything about it. So in matters of creating new All India services, Rajya Sabha has more powers than Lok Sabha. So A would be wrong. Second, amending the constitution. Third, removal of government. D, making cut motions. Rajya Sabha cannot make cut motions. Removal of government has to happen in Lok Sabha. The majority has to be proved inside Lok Sabha. So amending the constitution is the correct answer. B is the correct option. In fact, if there is a constitutional amendment bill, there cannot be a joint session. That bill has to be passed separately in both the houses. Okay, because Rajya Sabha has equal say in amending the constitution. If there is a joint session, because of its numerical majority, 543 members in Lok Sabha, compared to 245 current members in Rajya Sabha, Lok Sabha has high chances of getting a bill passed in case of joint session. So that is why amending the constitution has to happen separately in both the houses. B is the correct option. Now there is this question on MP lads. 33rd question. MP lad, this currently why this question has been asked, try to understand, because they have cut the MP lad. The government has cut the MP lad because of the ongoing corona for 2 years, 2020 and 2021. So they have asked this question because this was making news. So please keep your eyes and ears open to what is happening around you. If anything is making news and it is given in your syllabus, it's coming in the exam as this question. So what are they asking about MP lads? First, MP lad funds must be used to create a durable asset like physical infrastructure for health and education. Correct. This is given. You cannot create undurable stuff like assets like Manrega in MP lad. There has to be durable asset. A specified portion of each MP, each MP's fund must benefit SC/ST population. Yes. 15% in case of SC and 7.5% in case of ST. If at all particular constituency is not having enough number of SCs or STs, then it has to be still there has to be some provision in that constituency, or maybe the fund can go to that constituency where there will be sufficient members from SC and ST community. So second is also correct. Now next also is MP-led. Next statement is MP-led funds are sanctioned on yearly basis and the unused fund cannot be carried. No, unused fund can be carried forward. See, an MP of Lok Sabha has a term of 5 years, an MP of Rajya Sabha has a term of 6 years. So it's not like in first year they're unable to utilize, then that would lapse. It can always get carried forward. It's not a budget. It's MP-led. Budget cannot be carried forward. That's why there is March rush whenever the fiscal year is ending when it comes to budget. Third statement is wrong. Fourth, the district authority must inspect at least 10% of all works done under the implementation everywhere. Yes, this is correct. The authority has to come here. They have to inspect at least 10% of the works. So 1, 2, and 4, that is option D is the correct option over here. Now 34th, which one of the following categories of fundamental right incorporate protection against untouchability? It has to be right to equality. Article 17, right to equality is from Article 14 to 18. Article 17 specifically says that untouchability would be banned. So it is right to equality. And it's natural if anyone considers anyone else as untouchable, then it's a violation of equality. So right to equality is the correct answer. Article 17 says, in India, separation of judiciary from the executive is enjoyed by, the correct answer is DPSP. Article 50, you can read that. It is the DPSP under Article 50. B is the correct option. Now, along with the budget, the finance minister also places other documents before the parliament, which includes the macroeconomic framework statement. The aforementioned document is presented because this is mandated by option D, provisions of this Fiscal Responsibility and Budget Management Act. Now, this FRBM Act 2003, Section 3, Clause 5 says it actually instructs government to make an assessment of growth prospects for the economy. So it is the FRBM Act, Section 3, Clause 5, which the question is asking about. Next, a constitutional government by definition is a limited government, option D. I have posted this question on my Facebook group, Indian Polity with Kanish Shekhar, if you remember. Constitutionalism, constitutional government. Why there is a constitution? So that the government functions as per the constitution. Constitution shows the way. Constitution puts the limits on the government. Government cannot act on its whims and fancies. If you want to bring a law, this is how it has to be done as mentioned in the constitution. So it is the limited government. Next question. Other than the fundamental right, which one of the following parts of the Constitution of India reflects the UDHR, the Universal Declaration of Human Rights? So in preamble, you will come across all these equality, liberty, and fraternity. So preamble would be there. DPSPs also want to make India a welfare state to assert socio-economic justice and equality, not in fundamental duties. Fundamental duties are for the citizens, not for the state. So 1 and 2, that is A would be the correct option. Both preamble and DPSP, when you read them in details, you see so much similarity with UDHR. Next question is, in India, legal services authority provides free legal service to which of the following type of citizen? Now, in this question, actually, a person with an annual income of less than rupees 1 lakh, second, transgender with an annual income of less than 2 lakh, member of OBC with an annual income of less than 3 lakh, and fourth, all senior citizens. Now, this question is a slightly ambiguous because there are different provisions for different states. All senior citizens are not provided, but in Delhi they are provided because Delhi government has mandated it. So we cannot generalize this question. Which one is the correct? Which state are you asking about? Of course, by elimination, I can arrive at the correct option, that is A. 1 and 2, person with an annual income of less than 1, and second, transgender with an annual income of less than 2 lakh. Having said this, I can assure you that there are different provisions for different states, but seeing the option in prelims, you always see the option to arrive at the correct option. So eliminating 4, and there is no such provision for OBC. So the most feasible option here is 1 and 2 because it is happening in certain states. So by elimination, I arrive at option A. There is no generalized, there is no one solution for this question. So I guess this is all that we had for polity. I hope you understand. And if you see conflicting answers from other tutorials and other teachers, I mean, ask them. I can justify my answers. My answers are based on my understanding of the Indian Constitution, which I have been studying for as long as I remember and teaching for past 8 years. Correct answer key would be released by the UPSC, and that would come when the final result will be declared. So again, up to you. See the books, see the notes, see the solution. Feel free to interact with me in all these YouTube and Facebook and other forums where we are doing it. All the very best to you. Prepare well and take good care of yourself. Bye.